Sorry for all those people that are having digesting problems and don't want to think about poop this early in the morning. I did it. I think it was nerves. I just don't. I don't think it was food poisoning. Sorry, Judge. Not believing it.
Emotion and nerves.
Yes, emotion and nerves. Let's be honest. You had those cheeks flapping, right? Those cheeks are flapping. You weren't feeling too good, Judge. You mistaken Kayla for Kaylee. Kaylee for Kayla. And I do want to say this. Shannon Gray, clever attorney. Clever. That man was able to wield insults at the judge under the guise of freedom of speech. You're going to get to see that. It's later in this, but it's so hilarious. It is so hilarious when you see there because he's talking about, if I were to say you're crazy, Judge. I wonder where was that on the top of his head? I'm just wondering. Very clever attorney. Very clever. This is going to be brought up later, especially if this goes to an appellate type of situation, is the fact that he feels that he has the right to dictate what people say. And I think that that's going to be the crux of their argument, is that we have freedom of press. That means you're not to be hindered in your reporting. Yet this judge is on the record stating that he wants to restrict and basically tell them what they are allowed to write about and say and produce. And that is a big problem for me. It's a big problem for me. I don't know if this judge is making that connection or not, but the people out here, at least me, I mean, I think I have a fairly good understanding. I don't know all the intricacies. That's why we have case law and we do legal research and stuff like that. But I don't know all the intricacies of a lot of stuff, but I have a good understanding of the law in general, the United States law, as well as state law, as well as how the states are broke up and what laws they govern. There's different sets of laws, whether it's community property or common law. I mean, you've got a lot of different things that you have to look at when you're looking into these, but I still have a good understanding of the law. And no matter what kind of law you're talking about, from my understanding, you can't tell the press what they have to write about and how they have to write it. Now, to me, that seems in clear violation of the freedom of press, in my opinion. And I think the argument is there. And I think this judge is doing himself a disservice. I really do. Just my opinion. I think he's doing himself a disservice. It's not even, he wants the press to go out there and teach and educate their audience on the criminal justice law. Sure. Happy to do that. We got something coming up right now after this. It's Nebraska Press Association versus Stewart, right? What you constantly keep hearing them say, right? We're going to listen to that argument. We're going to educate our audience. We're going to educate you. Stay here. Since the judge is telling me what I have to be able to, what I can and can't do on my channel, what I can and cannot say on my channel, he wants us to educate the public? Sure. Happy to, Judge. I don't think you're going to like my education because I hone in on the First Amendment, freedom of speech, the cornerstone, the bedrock of every single law we have in this country. I hone on that quite a bit. We'll go over what you need us to go over, Judge. Happy to do so. We're here, right? This is the Bullhorn Betty channel. We want these animals off our streets. We want safe roads. We want good environments. That's what the Bullhorn Betty channel advocates for. Happy to educate our audience, much like we have, about how this is a horrendous non-dissemination order. We are educating our audience on the law. Believe me, Judge. Believe me, I'm educating my audience on the law. I definitely am. Remember yesterday, before we even heard the hearing, what did I tell you we had? What did I tell you we were going to be going over? Remember that? Why do I have all this insight about what we need to be doing next? It's called common sense. Okay, it's not like I have the secret back door to these people in this trial. It's called common sense. And we already had it on yesterday. I said, you'll never believe what I dusted off, right? What did I dust off? We're going to go through this. We're going to teach you about criminal law and procedure. This is a book I got from college. Dusted it up. Had to blow some of the cobwebs and dust off of it. We got it. One of many books, by the way. One of many books. We have all this kind of stuff, this technical writing. We got our citations book, our legal citations book. You know, we've got all of our tools that we need. We got all our tools, stuff that I've had for many years. The rules they're trying to incorporate this ethical guidelines and ethical rules that are already part of them having their license and maintaining it. So that means the Idaho bar, like we have the Florida bar, the Idaho bar requires them to maintain certain requirements, including ethical training and adhering to strict guidelines to be an attorney in the state of Idaho. They've already got rules and regulations that govern their license. They don't need to have an order referring them to what's governing their license. Every attorney already knows. Like, you don't want to be in front of the Quality Judicial Commission. You know, you don't want to be in front of them. It's even if you're innocent, you don't want to deal with them. Nobody does. So this doesn't. The regulations are already in place. They don't need to be. What is the word I'm looking for? It starts with the I. Redundant. We don't need redundant stuff. The redundancy is ridiculous in this case. Way over the top. I think that is the gist of the legal community related to this. I really do. I mean, I have to be honest with you. I have been out of attorneys' offices in courts for many years now. I mean, at least close to a decade. Maybe less than a decade, because I was married for a decade and I was still working for a law firm when I was first married. So, I mean, it probably about at least 5 or 6 years. I've been out of the biz for at least 5, 6 years, maybe 7, might be 8. I can't even remember. I can't remember when my last day, right? I can't remember. But either way, and granted, you can be in law your entire life and not run into some of the issues that we see here, you know, covering true crime. You can work in the business your entire life and not have a lot of these issues ever be presented for you. So just like the judge is, in my opinion, doesn't have the experience in this type of case, it's hard for anybody to have a total experience in these types of cases in totality. It's just very difficult because there's so many nuances. There's so many different arguments. There's so many different defenses that it makes it, all they really have is a standard procedure to follow, right? So it's just, it gets into these tricky topics that it's hard for us to prepare for. This is one of the situations. And just like the judge, I am ignorant and in some respects. And I also don't have the experience in a lot of this stuff. I mean, we're gaining experience every time we watch these trials, every time we see how they're processing the evidence. You know, when we're growing up and we're watching, say, like the first 48 or forensic files or things like that, we're only seeing those aspects of the case. We're not seeing how those work in conjunction with a trial. We don't have that where it gives you the full circle from the investigation from the first 48 hours to the actual processing of evidence, the forensic files, to the court, i.e. like court TV, how those all play. The only time we get that in good context is to watch these trials and see how those are built. But we still don't understand it unless we're watching from the beginning and know exactly what was collected, know exactly what was processed, and know exactly from what was collected and processed to what is being admitted in trial. There is a disconnect there in the education of media, in education of news reporting. I can agree with the judge that, hey, some of these processes need to be explained to the audience, and we're going to do that. And we were planning on doing that before he ordered the press to do that. A judge ordering the press what to write, speak, and talk about. This is not the America I grew up in. Sorry, just not. Let me really, really piss the judge off, right? Let's really get under the judge's skin today. Like, I'm looking at Brian Koberger's body language, and he just does not look pleased. He looks like he's guilty to me. Oh, I'm sorry, Judge. Are you going to hold me in contempt of court? I'm just curious.
Regarding the prosecutor's actions prior to trial. None of those things apply to the victim's family or the victim's attorney in any way. Now, I do references that multiple times as the basis for her non-dissemination order in this case and how it might apply to me.
So they're saying that it's pretrial publicity and how it's going to be applying to this witness's attorney. Now, mind you, they're stating that he's not a witness to the crime. The family's not a witness to the crime, not a witness to anything, but may, not shall, but may be called as a witness in the sentencing phase. That means after the conclusion of the stinking trial, by the way. He's clenching his jaw, folks. He's clenching his jaw. He must have been guilty. He has to have done it. He clenched his jaw. And he's using a Bluetooth brush.
Not me.
Attorneys who are representing witnesses.
See, this is where they're trying to open a back door to a witness of a sentencing. This Gonzalez family is not classified as a witness to the facts of this case, which is what they're trying to prevent from getting out into the public. So if they don't have any testimony related to the facts of the case, having to have information that can't be publicly stated doesn't make sense. None of this entire proceeding to a normal person, to my normal brain, makes sense.
Can be.
What access, Judge? Particular information what? Because they went out and collected the information. Let's put this into perspective. They're trying to bar. Now, mind you, they have no evidence, no witness, no nothing that the state has provided them. They have gone under oath. They've even stated here under oath to this judge through their attorney that they have never had any information, never been questioned by the state attorney, but somehow the state attorney is still labeling them as a witness, and they've never even had a meeting with the state attorney. Not even a meeting. Not an interview, not a deposition, nothing. This is a prosecution that is not holding his law license too well when you're going to manipulate and purposefully, with malice, lie to a judge about a witness's family or about a victim's family. That to me is disgusting. And if this shows me how Bill Thompson or Thomas Thompson is going to be running this case, I'm very concerned. I'm very concerned as to whether Brian Koberger will truly receive a fair trial. And what other tricks, nasty little side tricks, is Bill Thompson holding up his sleeve? This is a trick. This was dubious. I almost want to say fraud upon the court. Let's see how they can stretch this garbage. You're saying it's possible. You're indefinitely restricting somebody's First Amendment freedoms of press, freedoms of speech in a case on a possibility. And this attorney is absolutely right. That is not good enough. It is not good enough. You cannot do this. This judge should be, at this stage in this judge's career, he should know these things. I am a flippant paralegal from Florida. This is criminal law 101 in my opinion. And I think that these lawyers just get on these kicks where they go into all these different rabbit holes and try to look, it's common sense. This judge is being ridiculous in this matter. Absolutely ridiculous in this matter. He's so scared to make a mistake. He's making mistakes all over the place. So the victims can say whatever they want, according to this judge, but their representation cannot. That seems like, what is the purpose of having counsel represent you if your counsel can't even speak? And this judge is literally entertaining this nonsense, right? What Supreme Court will allow a retained attorney not to speak on behalf of their client? You tell me what Supreme Court in this country is going to side with this judge on this one matter alone. You tell me. I'm interested. Find me a judge that would say that this is okay. A Supreme Court judge, not a magistrate judge, not this ridiculous guy sitting behind the podium here. A Supreme Court judge that has handled plenty of cases. This is showing this whole thing. You know, I was so hopeful when we found out about Brian. I was so hopeful when we found out that we were getting a new judge on this case, and Megan Marshall, a magistrate judge that just doesn't have the experience, was stepping down, and I was very pleased with that. Now we get this Yahoo judge that is basically a spitting image of Megan Marshall. It doesn't look like he knows whether to scratch his watch or wind his butt. And I'm sorry, this is becoming a very unprofessional trial, and it's magnifying the ignorance of this court and the prosecution. You expect this from the defense. That's their job. But from the judge and the state, this is for a person like me and normal people that understand these things. Like, I don't expect my audience to understand the law. I mean, that's why they hire attorneys. But for the law professionals that are out there on social media, Twitter, Instagram, YouTube, and otherwise, why are they not talking about this? An attorney is hired and can't even represent his stinking clients. What Supreme Court is that okay in? And again, how is somebody going to possibly be able to explain to a judge every little thing that could possibly come up? It's not. And if this judge is using that same standard, what are you not allowed to say? Well, if the non-dissemination order is not working, Judge, maybe it should just go away, because this is a lot of judicial resources being utilized to keep an unconstitutional non-dissemination order in play here. Now, I would have to warn our audience, as well as people that may be watching this video later, that this is a vacuum that was created by this non-dissemination order. They're complaining of the repercussions of this non-dissemination order and the misinformation being peddled out there through media and social media, but they're the ones that created this this misinformation campaign, because they are refusing to allow anybody to even glean information such as, how is the community healing? They even went as far as to put into their pleadings, one of their memorandums or their objections or their statements, that, they're not even asking, are they sure they got the right guy? My thing is we're not even allowed to ask that under this current non-dissemination order, because all they do is cite the gag order as the reason for them not being able to respond to that question. So again, this is being created by this non-dissemination order. They're angry that their non-dissemination order has created this horrible issue with misinformation being peddled by Dateline. Now, mind you, that came after the non-dissemination order. Every single one of these documents that I have reviewed, let's pull it up. I got it all right here, right? All these documents that we have reviewed in connection, this is not the package. That's the package. This is the first package. Hold on. I got the wrong package. Now, mind you, this non-dissemination order has been in place since January 3rd, the day that Brian went to his hearing or waived extradition and was on his way back to Idaho. Megan Marshall put in a non-dissemination order. Actually, she filed it, but guess whose name was on that non-dissemination order? Oops, that way. That man right there, John C. Judge was the person that signed that initial order back January 3rd, 2023. Nothing that was diminishing, nothing that would have prevented Brian Kohberger from receiving a fair trial. None of that. You according to this court, they don't even want you breathing Brian Kohberger's name, unless we're talking about kitties and puppy dogs and anything but murder. We can talk about Brian Kohberger, according to this judge here. We can talk about Brian Kohberger anytime we want to, just as long as we don't discuss the case. I'm sorry, Judge, you do not have that authority over me. You do not have that jurisdiction over me, and you do not have that jurisdiction over the majority of the news conglomerates out there. And while you may like your local news and may want to give them a boost in views and clicks and money, at the end of the day, you are beholden to all of us, not just your local news organization. Conferences and press releases. Let's not forget that. All this stuff that they're listing in this article was provided to us by law enforcement. Every bit of it. How is this preventing Brian Kohberger from getting a fair trial? So you see the gist of the reports of the articles before the non-dissemination non-dissemination order went into place, and you see how radical and crazy the reporting got after the non-dissemination order went into place, leaving me with the conclusion, if you actually look at the evidence and information, Judge, you will see that the non-dissemination order is the cause of all this problem. Remove the freaking order or modify it under the law properly. That's all I'm saying. So there you got it. I'm educating my audience with the facts of this case and how ludicrous these arguments are for this non-dissemination order, and to classify the Gonzalez under a weak, they could possibly be called as a witness in the sentencing phase. Yeah, let's see how well that flies in the Supreme Court, buddy. Like, okay, they're going to shut your butt down. They're going to shut your butt down. On my rampage of complaining about this non-dissemination order and how ridiculous it is, and how it's doing exactly what the judge is saying he doesn't want happen. I mean, it's the document causing the problem, dude. If you haven't figured that out, I don't know if you're the right judge for this case. I'm just saying. The proof is in the pudding. We just read the proof. Much better reporting prior to the non-dissemination order. Period. Hands down. Much better reporting. much more factual information, much more concise information, and it didn't prevent Brian Kohberger from having a fair trial. Imagine that. Imagine that. You know what? That's the whole purpose of them having an attorney, so that doesn't happen. This court is preventing that attorney from speaking on their behalf to prevent that very thing right there, the heat of the moment aspect. So again, the courts are creating this issue and then pissed off that this issue is created. They're doing it to themselves. And I don't know how to express it or explain it any clearer than this court is doing all this to themselves. They're creating this vacuum. They're creating this circus, and they're preventing us from getting factual information that we can use to stop with the misinformation. We're not asking for information that's going to jeopardize the stinking case. Not every tidbit of information in this case has some aspect that will prevent Brian Kohberger from having a fair trial. That's why it is so overly broad to have a blanket non-dissemination order, and why it's so wrong in these courts to have a blanket non-dissemination order, which will not pass legal muster in the Supreme Court. It will not. This judge is going to have, if he keeps this going, he's going to have a very difficult time explaining his position to this court, to the Supreme Court. He's going to explain it in his way, the way we're hearing it here, but it's going to fall on deaf ears when you actually have judges that know how to interpret the law. This judge is taking his direction from a defense attorney and a state prosecutor and not using his noggin to properly properly handle these debates of this case. He's listening to this. He's acting like he doesn't have a brain for himself. When you heard him say, I'm an officer of the court, what he is telling this judge is that I'm an officer of this court. I'm bound by ethics, and I have to be truthful in my dealings with you, sir. And I'm telling you, as an officer of the court, we've had no interaction. So he's basically saying to the judge, I'm testifying, telling you that my clients have had no interaction with this case and have no inside information about this case other than what they've garnered on their own. And that judge cannot prevent them from talking about stuff that they garnered on their own, only what the investigators and the parties to the case have and the information they have. If I went out tomorrow and researched this and found another person, a person of interest, or the person that did this crime, not Brian Kohberger, you cannot prevent me from going forward and saying, hey, I found the real killer. You can't stop me from doing that. I found that on my own. I'm allowed to bring that to light. Now, once I bring that to light, you might be able to go to court and say, hey, she's got some inside information and this is prejudicial. We need to silence her. And then maybe they could have enough meat on the bone to silence me at that point. But the action has to be, they can't just assume that I'm going to do this and restrict me because I might do it. They can't hinder my First Amendment rights over their assumption. And that's what it is. This is an assumption, and they're hindering all these people's rights over an assumption of something that has never even happened yet. Explain that to the Supreme Court judge. These non-dissemination orders are crucial in criminal investigations. When you've got a Yahoo judge that is overzealous with their non-dissemination order, it causes problems. And it causes problems for the rest of the judges that know how to properly preside over these types of cases. Unprofessional.
That a Judge Marshall, has tried to silence the attorneys for victims. Never has it happened.
And that is the truth. And that is where this argument is the most the strongest of Shannon Gray's arguments is that statement right there. I have never in the history of me working ever had a judge prevent the victims from speaking. They have no authority to do so. This judge may think he has authority, which is crazy to me, but I mean, he does have some wide authority over the parties of the matter, but you have to be a party of the matter. They're trying to retroactively state that there's a possibility that they may call him. Look, the Gonzalez can say, why don't you sign a thing and say, I'm not going to be a witness at the sentencing. Here's my statement for sentencing. Go ahead and write them an affidavit of what the statements will be at sentencing, and let's get that out of the way so he can't be a witness at sentencing. There's a way to do this. The way they're doing it is wrong. And what this state attorney is doing is just disgusting and despicable. That's all I'm going to say. It's disgusting and it's despicable what this state attorney is doing to the Gonzalez family. Shame on him. Shame on him. He is lying to the court. That is what Bill Thompson is doing. He is lying to the court.
Would you
My
feel
opinion.
more comfortable
Yeah.
if there was a
Don't
more
worry, Bill. He knows soon
concrete
to come to Florida.
description of what
Is this judge is saying he wants a fair. This is not about a fair and impartial jury. This is something bigger than that. Because this man keeps arguing about they're wanting to shut up the Gonzalez. It is very well positioned in this hearing here that this is a hit to shut up the Gonzalez family. And here's why. Because the judge is trying to make this stretch that they're going to possibly be a witness at the sentencing phase. Again, after the verdict, after the jury has concluded their job, they may be a witness. Again, if this is about a fair and impartial jury, that is a moot point. What is done after the verdict is a moot point because the jury was fair and impartial in getting that verdict. So you're talking about things that don't even make a difference if that's truly your objective is the fair and impartial jury. Why are you arguing about what they can say if they're not even going to be part of the trial, the actual physical trial, while the jury is present, while the jury can take testimony and later deliberate if it's about an impartial jury? It's not about an impartial jury. This is painting a very clear picture that this is to silence, that the state attorney is willfully and maliciously trying to silence the Gonzalez family. And if this judge doesn't pull his head out of his butt, they're going to have a massive lawsuit that he's most likely going to be a part of because of the crap that the state prosecutor is doing. And this state prosecutor should be held liable for his conduct. Lying to a judge, in my opinion, that is exactly what he did when he tried to classify the Gonzalez as witnesses. He maliciously and willfully misrepresented information to a judge.
position that you are representing yourself.
Yeah, I hate to break this to you, Judge, but when he takes his attorney clothes off, he's allowed to put his personal clothes on, and he's allowed to think, talk, and walk for himself. And guess what? That's also protected under the First Amendment, Judge. I know, shocking. I know it's shocking for somebody like you to comprehend at this point in your career, but I digress.
Oh.
All right, so I want to be very, very, very clear. The only thing that dictates law is the law, okay? There's right and wrong. Now, I can't help that there's people out there that are idiots that have no understanding of the law. If you want your rights violated, by all means, go to Latah County. You know, go get a criminal charge in Latah County. It has nothing to do with other than educating my audience, which this judge has asked everybody to do. So I am taking his challenge. I'm going to educate the heck out of my audience about the law. And haters, you might want to stay tuned. It might help you in the future. We know you guys like breaking the law because you guys try to say you don't know that you broke the law. But unfortunately, that's not a defense in the United States. I didn't know that I broke a law, so therefore I'm not responsible. Right? So you guys want to have unfair. I have a very good understanding of trials. I have, you know, right? Everybody keeps saying I don't know what I'm talking about, right? But I've, been arrested, 43 times, according to the haters, which is a lie. They know it's a lie. They still continue to peddle that lie, right? So, but I've only been charged with 2 things: convicted of 2 things, one from 20 years ago and one from 11 or 12 years ago. Ooh, big deal, right? So we just had a credit card issue, right? Everybody was on here. It was my ex-husband's credit card. Had nothing to do with me whatsoever, but obviously know the law there, right? Dropped, moved on, right? Right? Everything when it comes to this has been spot on. In all the cases that we have covered, even with some of the intricate laws and stuff like that, we may not get the specificity specifically right, but we definitely always get the spirit of the law correct. And that has been proven for the last 2 years. Like, you can't dispute that. So this idea that I don't know what I'm talking about, that I don't know right from wrong when it comes to the law, is absolutely incorrect. We are absolutely speaking about the facts, you know. And it's funny when I hear haters come into the channel and say, you don't say facts, you don't say facts. But then when I tell facts, they're like, oh, you're just upset because they won't let you grift. Really? Why don't you just acknowledge that you have no business being here on the Bullhorn Betty channel? Nothing I ever will do will ever be right in your eyes. That coming in here and disrupting my channel is doing absolutely nothing for your cause. Actually hindering a business. Lots of stuff. Lots of stuff. It's okay. So this guy is literally reading from his binder, okay? You're seeing him, you're hearing him. He's like, you can hear he's reading from it. He's not formulating his own arguments and stuff like that. He's literally reading from this book. Those are the books that I used to put together for my attorneys, right? Where we put their legal arguments in. We wrote the whole book. All we had to do was follow the book. Like, yeah, you don't even have to think. Just follow the book. Follow the book. That's what we always told the attorneys. Don't try to go wing it. Follow the book. Follow the book. And I'm seeing this guy and I'm like, oh, he's got this. This is his paralegal's arguments. This is not his arguments. This is somebody's arguments, but they're not his. They're not his, because you can tell just by the way he's arguing this. This is not his arguments. He's just the one saying them. Can you imagine the repercussions of being able to prevent victims' families from speaking? You know, it wasn't until he was talking just now. I don't know why it didn't click for me yesterday. But just the thought of knowing that a state attorney and a judge actually wants to prevent victims' families from speaking. I think this is probably the most unprecedented aspect of this nation order. And I didn't think of it in that lens, but now that I'm thinking about it, to prevent the victims' families, when have I heard a law that has done that before? Or a judge that has ruled that way before? And I can't recall. Now, granted, I'm only 43 years old. Some of these laws were way before my time. Hell, some of these laws that they're relying on were way before this judge's time. So, you know what I mean? That seems like the most unprecedented, that a judge is literally trying to prevent a victim's family from saying boo. That's concerning to me. And the fact that this judge, this particular judge is entertaining these arguments is even more concerning to me. And the fact that I just heard Bill Thompson go up there and lie to a judge, but he didn't really lie. He lied, but he didn't. Oh, well, they could possibly be called for, you know, the sentencing aspect. That is a lie. I have never in my life, good morning, Hellcat. I have never in my life heard that somebody can't speak because they may be called in the sentencing phase of a case. I mean, call me crazy. I just never heard it.
Prohibition of extrajudicial statements is the...
Yes, the prohibition of extrajudicial statements of the parties. Even the witnesses can talk. Did you guys hear that? I don't know if you realize that, but part of their argument from Shannon Gray was, wait a minute, the witnesses are allowed to talk, but I'm not allowed to talk on behalf of my client? But for some reason, they're not allowed to talk as witnesses.
Response
I know what this guy lacks. I know what it is now. I couldn't put my finger on it, but I figured it out. Confidence. He's lacking confidence in his arguments. That's why he sounds so robotic. It doesn't sound robotic, you know what I mean? But he seems like he lacks confidence in his knowledge of these things. That's what I couldn't put my finger on it. There was something with this attorney, and I couldn't, like, you can tell he's green. And if he's not green, oh boy. The best advice I can give this man is mirror and practice. Mirror and practice. Look at your body language, look at your facial expressions, and recorder. You need those things. This man needs a lot of help here. This is not going to be good for his behavior, his speech pattern, everything to me is going to be distracting to the jury. I almost want to put a poll in the chat to ask, how many people honestly believe that this non-dissemination order is going to stop people from talking smack about Bryan Kohberger? How many people? Right? I mean, like, seriously, how many people honestly believe that this non-dissemination order is going to prevent people from talking smack about Bryan Kohberger? Like, is this court living in a fantasy world or something? Like, I don't get it. I just don't get it. Am I wrong? Am I wrong here? The haters are going to try to say I'm wrong, right? But at this point, what difference does it make? I mean, we all know who all the key players are. It's like, oh, they're still using DM. Like, really? Like, the only people that don't know who DM is are people that have been living under a rock for the last, I don't know, 8 months. I mean, like, seriously. I'm going to be up here madly talking smack about this guy because I truly believe this man is guilty, and there is no court in this freaking free world that's going to shut my mouth when it comes to this. Absolutely not. Absolutely not. We have a right to discuss. We have a right to say he's the most horrible person in the entire world, right? That is our opinion. We are entitled to those. Those are something that the courts can't take away from the majority of us. Now, granted, the courts do have, I mean, you know, realistically, I know I put a lot of satire in some of this stuff, but realistically, the judge has a right to control what comes out of you. So see those people at that desk? He has every right to control those people. He has every right to control what is being disseminated from, say, law enforcement, the investigators in the case, right? But he can't prevent people from putting hypotheticals together, talking about perspective, getting people like, say, retired FBI agents or forensic psychologists to come on their panel to discuss some of the questions many of the audience have. They cannot prevent that from happening. Even in the current non-dissemination order, we saw that the articles that were written in with that non-dissemination order in place, it didn't prevent them from telling their perspective. Illinois newspaper, I don't know what you mean by, yes, he can. He cannot prevent me from speaking. That man right there in that courtroom, that judge, he can't tell me what I'm allowed to write, what I'm allowed to think, what I'm allowed to get. He can prevent the people of this case, the people he has jurisdiction over. Okay? Understand that. The law is the law. He must establish jurisdiction, much like the Supreme Court. And the people he has jurisdiction over are those people that are in that courtroom. Okay? He has no jurisdiction over me. He has no jurisdiction over the media. He has no jurisdiction over what he is allowed to let them say or not. He has no jurisdiction. And no, he doesn't. Let's be very clear about that. No, he doesn't. So, unfortunately, we're going to educate people here. We're not going to allow the uneducated to educate. We're going to educate people here.